Court. Following the judgments mentioned therein is a covered matter of Writ Appeal number 204 of 2013 of this Honorable Court, passed by the then Honorable Chief Justice, Your Lordship.
The learned magistrate has taken cognizance that the petitioners filed an application under section 210 BNSS to recall the cognizance order. That application 210 BNSS is pertains to the power of the magistrate to take cognizance. Not only the quoting wrong provision of law, but once cognizance is taken, the magistrate cannot recall. Any criminal court once takes a decision, it cannot recall. If the
Lordship, I am raising any disputed questions what are raised by the VPP. My humble submission to dispose of my criminal petition.
It is not a dispute.
My criminal petition is numbered. It is coming for filing counter by the police. It is maintainable or not maintainable. There is several judgments of Honorable Supreme Court, which is also filed by me in this court also. The Honorable Supreme Court category held. Your Lordship may kindly come to page number 18 and 19.
No, 1 second. You say that the trial court should be directed to follow the law.
Laid down by Supreme Court only.
Unless this court says no court is bound by the Supreme Court orders or what?
Because the trial court
Is every court bound by the orders or not?
bound to follow the law.
If you file the citation, they are bound to.
But
follow
in this case, in earlier criminal MP, the very same trial court failed to follow the Supreme Court judgments filed by me. So that I came before your Lordship.
For that you need a direction to follow the citation and dispose of.
Yes, yes, your Lordship.
The criminal MP prayer, your Lordship may kindly see what is the prayer, page number 68. My humble submission is once an application which is not maintainable even before the court, this court.
PP cannot decide it here, your Lordship, before your Lordship. The maintainability is the judicial order has to be passed.
Complete and get back.
On legal principle, I am not going entering into the facts of the case. On legal principle, I am saying under 210, this application is not maintainable. When such application is not maintainable,
let him file a counter, your Lordship. Your Lordship may pass reasoned order.
counter.
Let him file counter.
Counter. This argument. Your Lordship may record my statement. Your Lordship may kindly see page 68. Petition under section 210 of BNSS. This is power vested in magistrate to take cognizance. Once the cognizance is taken, if the party agreed is to invoke the other provision of the higher court. I am not saying that which provision. The learned magistrate who takes cognizance, he is becomes functional issue. He cannot recall his own order. Not only the magistrate, any court. But once such a provision is there, it can't be. Dishonorable court closing the eyes cannot direct the magistrate to pass orders on this application when such application is not itself is not maintainable. The very prayer is to recall the cognizance order. It can't be.
My humble submission, your Lordship, the courts are having implied power, ancillary power, express powers as per Sakiri Vasu judgment, which my honorable counsel not.
So the court which
It is the
which has passed the cognizance order can recall
it can recall order. But my humble submission before your Lordship is, I am not seeking to recall my order by force of this honorable court order. My simple prayer is to dispose of my representative, my criminal MP, following the judgment laid down therein if applicable to the case. If not applicable, court may not consider.
reserved for orders.
Obliged.